Good afternoon, everyone, and it's great to be back with you. I am looking at the calendar, and we are much closer to the end of August than the beginning, and that means that all of us are trying to squeeze in our last glimpses of summer, hopeful that you're all able to balance a little bit of away time, although I know it is still plenty busy for many of us as we move toward the close of the month and get ready for the start of school for those of us with families and kids, etc. Let me give you a quick walkthrough of what we're going to cover today. If Kathy, you'd go to the next slide, please, I'll walk the group through the agenda. And there it is, thank you. So I will be opening things up as I typically do here when I host, and I'll cover our public health updates, and I'll also make sure that we talk about primaries for a moment. Today's a busy day, and we should make sure that you have a sense of what's happening around the state, both at the federal and state levels. And then Stephanie Fedorka is with us again, a regular contributor to the Business in 2022 webinar series, and will be giving us some quick updates on the HERO Act, which is, of course, something both extremely important to the businesses here listening in, and a topic on which Steph has presented previously. So Steph, thanks for coming back. I'm going to turn then next to the healthcare worker bonuses. I did cover those 2 weeks ago when I was here with you, and then we had a pop-up webinar about it a couple days later. I will note that there have been plenty of questions coming in around the ways in which the program applies to many of you in the audience, and we're here to continue answering those questions, and we'll share what we've learned. There have been some updates since last we checked in with you. Then Elizabeth Morgan is here. Liz is also someone who has contributed to this webinar series in the past, and she's going to provide updates on the employee retention tax credits, which are obviously an important part of our COVID landscape. And it's good to just know what's fresh there. And Liz is prepared to bring us all up to speed. And then as we have time, we'll make sure to get to your questions. And looking forward to walking you through all of this. So if you'd go to the next slide, please, Kathy, I'll get to the public health updates. And so the next slide after that, please, would also be terrific. And let me give you some sense of where we are with COVID nationally. And what we're seeing, thank goodness, is some continuing decrease in the overall numbers. We're at a 19% drop since the last 2 weeks, or over the last 2 weeks, excuse me. And when I was here previously 2 weeks ago, there was also a drop of about that same pitch. And so we're seeing some declines. Again, remember, this is as best we can measure things these days because there's so much happening in terms of home tests and unreported positives. And it's just not as easy to monitor as it once was, when there was, certainly in 20 and 21, fewer ways in which one could get tested, and more data flowing into public health agencies in order to provide data that we know to be reliable. So with all those caveats in mind, this is where things are as we report out today on the 23rd. Next slide, please. So if you look at the hotspots, again, based on what we know from 2 weeks ago versus today, things are cooling down a bit, as it were, around the country, which makes sense if we're seeing a roughly 20% drop. There's still some concentrations in the South, particularly those border states in and around the Washington, D.C. area. And so that's where we're seeing the most again, measurable activity in terms of COVID positivity. But, anecdotally, I will tell you that, certainly I still have friends and others who are unfortunately contending with infection. It's still happening. The good news, as we've reported, and, as I shared in my own experience, knock on wood, most people recover pretty quickly, based on the tools we have that we didn't a couple years ago. But people are still carrying the virus. So next slide, please. Thank you. So if you look at what's going on here in New York State specifically. What you'll find is that we have in New York seen an even more precipitous drop, which is good news. We're at a 32% drop from where we had been 2 weeks ago. And the recommendations are as they were before, just that, recommendations, indoor masking and otherwise a level of caution. But there is much more of a move across jurisdictions to learn to live with the virus as we move into the school year. As I alluded to a moment ago, many school-age kids are going to be going into mask optional environments, and we're really at a different moment than we were some months ago around the various public health restrictions. Let's go to the next slide, please. So getting a little bit deeper in terms of what's happening in New York, looking at various geographies, again, you'll see the 32% drop across the state, which is good news. We'll take it for sure. And that is, a rough doubling from the 16% that we saw the last time I was with you. And you'll see that in New York City, for instance, there's a 34% drop that builds on that previous 18% drop, and other indications of decline across the state. In some of those smaller counties, for instance, like Fulton, where you just don't have the same numbers overall, there's more volatility. And so we're seeing some bumps up, in those geographies, but doesn't represent really what we're seeing on the whole across the state. So with that, why don't we move then please to the next slide, Kathy? And, we're no longer in a moment where COVID is our single public health challenge. Monkeypox is, of course, something that we've been talking about here on the webinar now for some weeks, as we've learned more about its spread and otherwise the nature of the risk that it represents. And what we're seeing, unfortunately, is more evidence of community spread, including in New York, there's a confirmed case with a child. And this will, of course, have implications for the start of the school year. College campuses are certainly preparing both in terms of educational policies and as well thinking about vaccination. We know that we have many institutions that tune in here, and so we can, of course, talk with you offline about specific recommendations we may have in this space for you. And Governor Hochul just yesterday made public remarks about this in the context of heading back to school. It's also important to note that through the Department of Health, there's support at the commissioner level from Dr. Bassett to take on the approach of essentially splitting vaccines. Rather than utilizing a single dose, there is another way to administer them where one dose can be spread among 5 people, which allows the vaccine, of course, to be utilized more sparingly, given that we are still dealing with some of the supply chain issues I reported to you previously around acquiring the vaccine. So expect there'll be more talk about how those who are at risk get vaccinated, and we'll continue to bring that material to all of you, particularly if there are implications for your businesses and requirements that you may ultimately have to be considering in this space. But for now, we provide you with the more general updates that I've shared here. Why don't we please go then to the next slide, Kathy? Thank you. Polio is also still with us. We, in this instance, have a virus that is making a comeback, one that in most corners of the world has been functionally eradicated, but we are seeing it in New York. And unfortunately, about a month ago, there was an individual that who is a young adult who has been paralyzed as a result of contracting polio. And so Commissioner Bassett, again, has come out with a focused set of remarks, including an op-ed in the New York Times around how this is something that from a public health perspective, certainly we're all taking seriously, or New York State leadership, I should say, and that it is expected will have implications in communities where there is lesser vaccination than there are in some others. We'll keep watching this for you, and we'll report out if there are things that you should know as it relates to how you again, conduct your businesses. But with that, I think we've covered what I was intending to touch on with public health. And let's switch to another biggie, which is the Inflation Reduction Act of 2022. Last time I was with you, it had cleared partially the legislative process, still had to get through the House. As I recall, it was, we were waiting on August 12th when we expected the House would get to it and pass the legislation. Indeed, it did. And then President Biden very quickly signed it. And so what we have now is some of the biggest legislation relating to energy and climate, as well as aspects of healthcare that we've seen in a while. And the implications of it are still ultimately unfurling. There are plenty that affect older adults, for instance, when it comes to the Medicare program, as just one example. And for those of you who work in spaces, indeed energy and climate, for instance, we know we represent plenty of organizations in that space where there will be aspects of this that, again, affect the way you go about your work. We'll keep you apprised. But for the moment, what had been legislation on its way is now formalized, signed into law by President Biden. Let's go to the next slide, please. And we would be remiss if we didn't talk about primary day. It's August 23rd, and many of you, I'm sure, are scratching your heads, as I was certainly when thinking about August 23rd as a date when we would all be in any of the regions of the state where this primary day is relevant, getting out to vote. But with redistricting, there was a lot of change across the state, as many of you are familiar, and we've talked about here before. And so there are competitive races for, what are primaries for Congress, including in New York City, just two I'll mention. I've earlier cited the 12th congressional district. The 10th, where I happen to live, is also now reconstructed in terms of its boundaries. And in those districts, the New York Times has come out in support of Dan Goldman and Jerry Nadler. We will see as the day progresses whether in what are competitive primaries in both jurisdictions, if we happen to know who the Democrats will be. And in those jurisdictions, of course, that holds very significant weight. In other parts of the state, we're also looking at an open seat that's up for a special election. You may recall, of course, that Lieutenant Governor Delgado was a member of Congress and vacated the seat to become Lieutenant Governor. And Mark Molinaro, who previously had run for governor against our previous governor, Andrew Cuomo, is seeking that seat in a special election, which would essentially put him in Congress if he were to be elected right away. We're also looking at state Senate activity. There's plenty going on. I'll give you just a brief high-level update. Senator Gustavo Rivera, who chairs the Senate Health Committee, is being primaried, and he is not certain actually to win this primary based on the nature of competition. It'd be a really interesting moment in healthcare in New York State if Senator Rivera were not to be able to continue. We, of course, saw Dick Gottfried step away, another long time, if not the longest serving leader in the assembly setting around health. And so that would leave really a wide open set of opportunities for new leadership to step into around health, which certainly in my practice is relevant. I know many around the client base that we serve are focused on healthcare generally. So we'll be tracking this and the other primaries closely to keep you apprised in terms of what's happening on the state side in New York. So again, August 23rd, not typically a busy day for electoral politics. This year it happens to be. Next slide, please. So with that, I will step aside for a moment and make sure that all of you have a chance to hear from Stephanie Fedorka, who's back with us. And we're delighted to be talking about the HERO Act. For those of you who don't know, Steph focuses on labor and employment and is very steeped in that world and works with many of you regularly. She is a Syracuse Law graduate, and also she went for her MPA at Syracuse as well. Really interesting background that, of course, informs the quality that she brings to you and those other clients that she works with. And so, Steph, I wanted to give you the floor to provide us with updates on the HERO Act, which is something that you've done for us before. And so let's hear what's going on. The floor is yours.
Thanks, Gabe. And thank you all for joining us this afternoon. It's great to be here again. I just have a quick update on the New York HERO Act. Next slide, please, Kathy. Thank you. So before we get into the update from August 17th, just quick background. If you recall, New York HERO Act was passed back in May of 2021, and it was two parts. There was the Airborne Infectious Disease Exposure Prevention Plan part, and then there was the Workplace Safety Committee part. For purposes of our discussion today, these regulations that we're going to talk about really only deal with the first part with respect to the Airborne Infectious Disease Exposure Prevention Plans. This only applies to private employers in New York as well. As a reminder, you'll recall that in August of 2021, you were required, if you were a covered employer, a private employer with a workplace or work site in New York State, you had to adopt a plan. The state had published plan templates that you could use on the Department of Labor's website, or you could adopt your own plan provided that it met certain criteria or certain minimum standards as set forth in that minimum or in those template plans. On September 6th, the New York State Commissioner of Labor declared or made a designation that COVID-19 was an airborne infectious disease that triggered the implementation or the activation of these plans. So what's nuanced about these plans, again, by way of reminder and background, these plans only have to be activated when the New York State Commissioner of Health designates the plans or designates airborne infectious disease as posing some serious risk to the public health. March 17th of 2022, that designation was not extended any further, so your plans could go back on the shelf. We'll talk a little bit about what that means in terms of when there's no designation in effect. What you still have to be, it doesn't mean that the New York HERO Act goes out the window. You still have to have those plans. They just don't have to be activated, and we'll talk about that on the next slide. But on August 17th, New York State Department of Labor published in the State Register the proposed final regulations and emergency rulemaking with respect to that first aspect of the New York HERO Act in terms of the airborne infectious disease exposure prevention plans. In short summary, they cleaned up the language a little bit in those regulations, but it breaks down into four main parts that I think are noteworthy for you all. The first is that it removed a reference to COVID-19 or references to COVID-19 in the regulation, again, with the intention being that this was a law that was passed and rules that are passed to help in the future if there's any other different types of diseases that could be designated by the Commissioner of Health to pose such a serious risk to the public health and require activation of your plans. So to make them more general and more applicable to other diseases and not just COVID-19 in the future. Verbal review. With respect to the verbal review, as you may recall, there was some question as to when exactly a verbal review needed to be conducted, and the verbal review of both your airborne infectious disease exposure prevention plans and your policies, as well as employee rights under the New York HERO Act. So in response to the comments that were provided, the comment period was open for a period of time. I believe in August of 2021, there was initial proposed regulations. And in response to those comments, they wanted to clarify when verbal review needed to be conducted. So the new language in the regulation provides that this verbal review must be conducted with newly hired employees upon hiring and all other employees as soon as practicable upon the activation of the exposure prevention plan. In other words, when there's a designation in effect. While this is intended to clarify when verbal review is required, I believe that the language is still a little bit ambiguous. However, our current best interpretation or read based on the framing of the comments is that this is only required when there is a designation in effect. So you would do, if there's a designation declared by the Department of Health, You would do a verbal review with all of your employees. And then if you hired any new employees during that designation period, you would have to do a verbal review with those new employees upon hire as well. If that changes, we haven't seen an update to the FAQs at this point in time yet, as of this morning when I checked the website. If any of that changes or that interpretation changes based on any developments or additional guidance from the Department of Labor, we will surely share that with you all. With respect to the exposure control measures, what they did is they took out a lot of the details regarding the types of face coverings, physical distancing, cleaning, disinfection, and PPE language, health screenings, etc. And what they did is they replaced it with a cross-reference that ties in and requirements or compliance with any state or federal laws or regulations relating to that airborne infectious disease at issue, including any adopted under the law itself, under the HERO Act, or Subtitle A of Title IX, which are government or governor's executive orders, or Title 10, which are the Department of Health emergency regulations or rules or regulations in the regulations, as well as any applicable guidance issued by the State Department of Health or the CDC. So what it did is it tried to, I think, make it more applicable, not just limited to or tailored to COVID-19, and directly incorporates compliance or requires or mandates compliance with whatever state or federal laws or regulations apply, executive orders, Department of Health regulations, or guidance that's issued by the State Department of Health or the CDC. Lastly, with respect to PPE, it clarified that employers must determine and implement an appropriate plan for ensuring that employees are provided with and properly utilize PPE in accordance with any state or federal laws or regulations related to the disease at issue, as well as governor's executive orders, Department of Health regulations, and applicable CDC guidance. So those are really the main changes that we have seen in this new proposed final regulations. Next slide, please, Kathy. So in terms of reminders, even when there's no designation in effect, right now there is no designation in effect, employers still have to have an airborne infectious disease exposure prevention plan. You must give a copy of to your employees within 30 days of creating a plan. I'm sure most of you already have those in place. You have to give a copy of the written plan to new employees upon hire. That is still required regardless of whether there's a designation or not. Have a copy of the plan posted in each work site, and update those plans as may be necessary based on a change in your operations or that otherwise is warranted by any changes in employee responsibilities or tasks or, again, operations, really. Stay up to date on the guidance. Right now, there are no update in the template plans or the FAQs, but I implore you to check in on the New York State Department of Labor, New York HERO Act website. If you have any questions regarding the template plans or the guidance is posted there, these updated proposed regulations are also posted on that site as well. And we will be sure to share any developments if we see any developments in this arena.
Steph, thank you. That was really instructive, and we appreciate you coming back. And it's certainly something that we'll want to make sure we keep our audience updated on. And so with that, let me say thanks. And I saw that there were a few questions that came in via the Q&A, and I'm further confident that if there's anything that you feel you can answer during my comments in a moment, that you will. And Steph is, of course, available for anything that you as an audience may have that requires further detail and thoughtfulness. And as always, Steph, again, thank you. So if we could move then to the next slide, please, Kathy, I'll shift back and walk everyone through what we know now about the Healthcare Worker Bonus Program. And I'll start with a bit of level setting. So if Kathy, you could please go to the next slide. Let me just remind you how we all got here. So there's a deadline of September 2nd, 2022, which is coming right around the corner, which has to do with this healthcare worker bonus program that I described to you initially 2 weeks ago. Why don't we go to the next slide and we can get into the details of it, please, Kathy. So it, as you may recall, derives from the budget that became law back in April, with more than $1 billion set aside for so-called frontline workers. And there are opportunities to, if you're an employee and one who's eligible, and that's an important set of ifs, to get up to $3,000 for what is deemed frontline work in the context of the pandemic, and with about 1,500 available maximally, exactly 1,500 for each of the vesting periods. So there's a lot of legwork and administrative activity around, well, how do you actually get this money out the door to those who ostensibly are eligible for it? We, of course, at Bond represent many employers, and so we've been getting many questions about how this program and its mechanics ultimately are unfurling. One other predicate that I just want to make sure to remind all of you about: eligible employees can't make more than $125,000 annually. And the role that they hold is really important in terms of whether they are or aren't eligible as essentially frontline workers. Next slide, please. So, what we'll get into in a little bit more detail are some of the various ways to think about eligibility for employers, which is something that we've been getting a lot of questions about because, candidly, it wasn't terribly clear initially because there is a statute which has essentially governed this activity, and the Department of Health has issued what amounts to sub-regulatory guidance through a website, through a portal, and more on this in a moment, but now has begun a webinar series of its own, which they're calling town halls. But prior to these opportunities, in particular the town hall, to dig a little bit more deeply, there were many questions that we, for instance, have brought to the Department of Health to see answered. And as of last Friday, some of them were and some of them were not. And it certainly pertains to that question of which types of employers are in this program and which are not. So also we want to remind you that there are attestation requirements and their timing of bonus payment requirements, all of which we'll get to in a moment and provide you with some updates. Next slide, please. So I mentioned in passing that there is essentially this, again, sub-regulatory guidance. And what you will find is a website that DOH has put forth, an FAQ, which has been updated actually as recently as August 19th, last Friday. The posting of that is now on the state's website. And much of what you see in that update is reflective of what the department covered in this webinar of last Friday. More on that again in a moment. Next slide, please. So again, on the level setting front, there are 5 successive vesting periods. We're in the first one right now, which is open through September 2nd and pertains to work conducted as between October of 21 and March of 22. And then there will be successive vesting periods. And there's a schedule at the very bottom of the slide that you can take a look at because this process will be repeating sequentially over the course of the next several months, running all the way into May of 2024. Next slide, please. So as I mentioned, this town hall, which was an effort by the department to aggregate all of the questions that we, among others, had brought forward. It's worth noting that on behalf of our clients, I personally submitted a variety of questions to New York State leadership in an effort to inform both the FAQ answers that we'll be able to now see as updated, and also some of the content that came up in the town hall. So we were glad that the department was listening and made an effort to be responsive on some of these open questions. We do expect there will be more that we'll be learning, as you see noted here lower on the slide. What the department convened on the 19th was the first of what will be, at present anyway, 3 successive Fridays at 11 with town halls, the next one coming up later this week. And so there'll be more that we expect will be coming out of those, and we'll bring that in distilled fashion to all of you. So next slide, please, if you would, Kathy. Thank you. Something that came out of the broadcast from the department last Friday is the schematic, which I credit the Department of Health for providing. And why I find it useful, and I think all of you may as well, is what it essentially does is really focuses in on who are qualified employers and who are not under this program, because many of the questions that we've been receiving ultimately amount to, am I in or am I out as an employer? And again, it hasn't always been patently clear as between the statute and the sub-regulatory guidance. But what the department sought to do through this schematic is basically describe two different pathways to get into the program. There's the pathway through the statute under 367-W2B. Just to remind all of you, that's the statute that authorized this program coming out of the budget agreement. And essentially what that pertains to are providers that receive payments through the eMedNI system. For those of you who are in that world, you are likely familiar with the fact whether you do or you don't. And then there are a variety of additional items that you also must be able to check the box on. Essentially, if you look at those four elements that are in the ovals that are within the middle column within the 2B section, you essentially have to be able to say yes to all of those things. And if you can't, then you're not qualified as an employer. And then there are further drill downs that go beyond that, particularly in terms of the facility types. Then there's a whole other category, essentially the 2C branch, and those are providers that receive payments from the statewide financial system. And for the most part, we can think of those as the O agencies, OMH, OPWGD, OASS, OCFS, et cetera. And also counties fall in there among some other categories, but generally pretty tightly constrained. And actually the FAQs that, again, were refreshed as of the 19th point that up. Next slide, please. It's also important, before I shift to the content here, just to remind all of you that we have a lot of questions that come from our clients in the education space. Broadly, education is being batched in a rollout as of October 1, not right now. We also know that we have organizations that we serve and otherwise we represent who have a foot in more than one world. They might be a healthcare provider, they might also be an education institution, and those points of demarcation are ones that we would want to study with you offline, because there isn't a one-size-fits-all answer really here. But it could have an effect on whether there are individual employees that would be appropriate to report and otherwise bring through the process for September 2nd, and others that would not be, all of which is part of a more detailed calculus that we can undertake with you if you wish to follow up with the bond attorney you work with most closely. Let's get to some of the tax implications. We were getting a lot of questions around whether employers were going to have to shoulder payroll and FICA taxes. DOH has now been clear. The answer is no. Essentially, there will be a flow through of funds on that in the distribution of the bonuses. And another important element, employers are not required to match 401k or other retirement accounts. We've got a lot of questions around that. And then if you look at the last arrow that I've included here concerning bonuses and New York State and local income taxes, they are excluded. And there's no state withholding requirement for employers. And this is all language from the DOH presentation that I have brought forward here. But there's more both in that presentation as well as in the FAQs on this. But broadly, this is all in the vein, as we read it anyway, as good news, because we were getting lots of questions from those clients we serve around whether and how they would be shouldering all of this. Next slide, please, Kathy. So also from that presentation, there was a whole lot of attention paid to whether employees, if one were to assume essentially their posture, could deem whether they were eligible for the program, because it's a two-part process, really. As a reminder, employees need to attest that they're eligible. Employers need to attest that the batch that they're submitting comprises their eligible employees. And so for an employee to figure out whether that employee is eligible, this step down process is mapped out here. And we can go through that in more detail with any of you offline. But with mindfulness of time, let's go to the next slide, please. And there's also a lot of focus on, or rather, employees who are not included in this bonus process. We can get far finer than we have the time for here, but it's important to note, for instance, that someone who's a worker at an exclusively non-patient building, an instance that came up I was talking about with another bond attorney yesterday involved laundering services that happens off-site. Obviously really important work, but it doesn't, if it doesn't happen on-site, those employees are not eligible, as just one example. So there's more here that we can get into the weeds with on you, and we just wanted to help you appreciate that DOH has started to define this a little bit more finely in ways that are helpful. Next slide, please. And then another big one, attestations. There was a lot of nervousness, I think it's fairly described, around whether employees could sign their attestations in means other than wet ink, actually pen to paper. DOH clarified that absolutely yes. If there is a process for electronic signature, that's fine, which makes the lives of employers who have to go through the attestation process of their own, as I mentioned, a whole lot easier. It makes the collection of those employee attestations much more straightforward. Many of you listening in have HR software and other tools that allow you to essentially batch materials out to your employees who may be scattered among many sites, and you now have the specific support of the department to do that. Next slide, please. So that is what I could cover in the somewhat limited time we have here, but please trust, we'll be tuning in on the 26th, then we'll be tuning in again on September 2nd, and many of you have reached out with questions along the way. We will answer them, and we look forward to helping you navigate this program, one that we know is new, it's important, and it's taking time to make sense of. But let me give you, with that, an introduction to Liz Morgan, or rather a reintroduction. She is also a Syracuse Law alum and also an MPA through the Maxwell School. So we have two different attorneys with that intriguing background here with us today. And Liz is in position to provide updates on employee retention tax credits. Knowing that we're nearing the close of the webinar soon, I want Liz for you to have the fullest time to address this area. The floor is yours, and thank you so much. Thank you all for listening in.
Thanks, Gabe. I'll be pretty short. I wanted to give an update on the employee retention tax credit. I'm a business attorney, and I work on this matter, practically on a day-to-day basis now. So just as background, as probably many of you know, the ERTC, it's a refundable tax credit, and eligible employers may claim this credit by amending your past quarterly payroll tax returns in both 2020 and 2021. Now, for the amount of the potential tax credit, that's something, accountants can crunch the numbers, but what I help clients is with determining eligibility of the credit based on the IRS legal standards. So generally speaking, as background, for the ERTC, there are two general eligibility factors. You can be eligible first if there's a full or partial shutdown order based on government shutdown orders. Second, if the eligible employer experienced a significant decline in gross receipts in a particular quarter in 2020 and 2021 based on the same quarter in 2019. What does a significant decline mean? In 2020, the IRS said that means it needs to be less than 50%. In 2021, it has to be less than 80% as compared to the quarter in 2019. So that's just the lay of the land. What I've been seeing with our clients is a significant increase in the in consultants reaching out to entities, not-for-profits, for-profits, large, small employers, offering their services to determine whether they are eligible for the ERTC and also preparing the tax returns, which is completely fine, except sometimes the analysis of these consultants is a bit shaky, to say the least. And their fees, you know, some of you may know, it might be a percentage of the credit that they deem that this entity is eligible for. The credit, you know, that fee could be due when the credit is, when the refund is received from the IRS, or it could be, you know, the fee could be due upon immediately providing these services. It depends on the contract. But I just want to do just a rundown of some of the key issues that sometimes I find some clients run into, because they, you know, this could be a substantial amount of money, this return. And some of my clients, they did not, you know, have any bad quarters, or they weren't really subject to any shutdown orders, yet these consultants are saying that they are eligible for the tax credit. So it's a bit concerning. So again, not all circumstances, but here are some of the main key issues. I find some pitfalls in some of these analyses. So first, a main issue is what constitutes a shutdown order. So it's clear that an order from a governor or a local administrator, you know, shutting down commerce, so that clearly that falls within the definition of a shutdown order. But what about other guidance documents, such as CDC guidance or OSHA regulations? There we get a bit more murky, and the IRS has not yet come out stating definitively whether those are or are not shutdown orders. But for my purposes, it's our opinion that not consist of a shutdown order. So that's one. You know, they'll say that you can rely on OSHA guidance. Secondly, what some people forget is that you can't just rely on a shutdown order. You have to back it up with some sort of information that you were somewhat negatively impacted from these shutdown orders. You have to specifically show that more than a nominal portion of the business was affected. What does that mean? Generally, for purposes of the ERTC, it means that you need to show that gross receipts have decreased by at least 10% from the prior quarter in 2019. So not only do you need to show that you were affected by a partial or full shutdown order, but you need to substantiate that with a reduction in gross receipts by at least 10%. You need to have two of those. Then we get into issues, you know, the eligibility factor is really complex. You know, we then get into aggregation issues. What if you're affiliated with other entities? We also run into the issue of the differences between large and small employers. Then we get into the issue of if you got a PPP, you don't want to do any double dipping. You cannot claim the credit on wages that were from the PPP monies used. So generally, those are the issues I've been seeing. And it can be, you know, like I said, a complex issue determining eligibility. I'll be also issuing an info memo on this soon, but if you have any questions about your eligibility, if you haven't thought about eligibility, whether you are or not, or would like us to review a consultant's contract or review, more importantly, their analysis to determine whether it's correct or not, please feel free to reach out to me or any one of my business colleagues. And Gabe, I think that's it. It was short and sweet.
Thank you, and very valuable as well. Appreciate you taking the time to bring us all up to speed. And Liz, please come back and keep us all updated as you learn more. So we're just about at the end of our time. And so I've been working to answer your questions in real time, as I know most of, Liz and Steph have been doing too. So I think we've gotten to most of them, but if there is anything that you want to raise and follow up, you can reach us by way of those emails that are up there on the last slide. And let me also remind you that your regular bond attorneys are here to help too, and feel free to reach out to any of them directly. I'll be back with you when we flip the calendar into September, right after Labor Day on this September 6th. And with that, I look forward to the end of summer, as all of you are, and getting ready for what's around the corner. Hoping that you have a good afternoon. And again, if you need anything from us, just please reach out. Be well, be safe, and thank you.